I'm Sarah Rajec, very happy to be here. Thanks for coming to my talk. This is the anniversary of my first academic law talk. The first time I did this also at DePaul, and hopefully this will be much better. Okay, so I'm talking about the IP hostage in trade retaliation, and I'm not actually talking about the TRIPS agreement. I'm talking about when the TRIPS agreement is used to push against other types of trade violation. So I'm talking about cross-retaliation through intellectual property at the WTO, and this is when a complaining country threatens to suspend obligations under TRIPS in response to an unrelated WTO violation. And two recent cases, although there are three of them, so it's a law review article, there are three total, but two recent cases sort of demonstrate how this actually works and plays out in real life. And the sort of surprise that comes from it, or maybe it's not a surprise, but is that what consistently happens is not that IP rights end up being suspended. This is a pathway to money damages, which aren't otherwise available through WTO dispute settlement processes. And so I show that this happens, and then analyze whether it's good or bad from a sort of global trade perspective, an economic efficiency type perspective. And then the piece that I haven't fully written out or thought through is what about from an IP perspective? So this seems like a good forum to get some input on my initial thoughts on that. The backdrop to all of this is that there's an ongoing debate in the trade literature about remedies. And so the question is, what is the purpose of remedies at the WTO? Are retaliatory measures meant to induce compliance? That's John Jackson and many other people think, yes, the ultimate goal is compliance, and so you can raise the retaliatory remedies as high as you want, because what you want is to force everybody to comply. That's the whole point of the WTO. Or are they meant to restore the balance of trade between countries, and thus can we contemplate that there might be an appropriate level of sanctions and even potentially efficient breach? So Al Sykes has written extensively about that. Okay, so that's sort of the background that happens. What is retaliation? An example is if you unfairly raise tariffs on the wheat that I export to your country, I go before the WTO, they agree that that's happened, it's done $30 million of damage annually, then if you don't bring your laws into compliance, I'm authorized to raise tariffs on car engines that you import from your country to me. So that's regular retaliation, and it's up to that amount, up to the $30 million annually. So it has to be an amount equal to the nullification or impairment of rights that I've suffered. Cross-retaliation is when a complaining country can suspend concessions or obligations under a different trade sector or a different agreement than the one that was violated. And that's allowed when same sector retaliation is not practicable or effective. So, for example, in 2003, Antigua challenged US laws against online gambling, saying that they violated the GATS agreement, the General Agreement on Trades and on Services. And so they won, and in 2007 they received approval. We were unwilling to change our laws. In 2007, Antigua received approval to suspend obligations under TRIPS up to an amount of $21 million annually. Okay, and then in 2013, there was an approval of a plan. So this whole thing takes a long time. There's lots of back and forth and appeals and all of that, but eventually there was an approval of a plan to suspend copyright protection over music and films for sales in Antigua of US holders of copyright. Okay, so you can see why same-sector retaliation might not have been considered practicable or effective. A small market like Antigua, if they were to put some sort of services tariff or quota on goods from the U.S., it would only harm their own consumers, because they're such a tiny market that nothing they did could really harm a U.S. industry. And so it doesn't affect anyone in the U.S. It does, and it just hurts them. And then another more general critique of normal retaliation is that what it basically does is add another trait distortion to the first trait distortion. So it's sort of a two wrongs are meant to make a right, and that doesn't seem like it makes sense. So that goes against the WTO goals. And then lastly, another general critique is that even when it affects the US industry, it doesn't affect the one that benefited from the first trade distortion. So in the case of wheat tariffs or something like that, if I put a tariff on car engines, that's a totally different industry that's getting harmed. Okay, so then an example from a larger country is that in 2002, Brazil challenged US subsidies to uplands cotton in the United States. So a large portion of the subsidies were found to violate the WTO and the SCM, and the US made some changes, but still violated. So this also was a very long, drawn-out process with lots of appeals and small tweaks to our law that didn't actually bring us into compliance. Okay, so Brazil received approval then in 2009 to impose countermeasures up to $829 million a year, and $268 million of that could be in IP rights suspension. So they're a very large market. They can, in fact, add some tariffs to stuff without only harming their own consumers, but there's a limit to how much they can do that. So in terms of whether it was practicable or effective to stay within the same sector, at some point the tariffs would just get too high. Also, a lot of the goods that Brazil imports are called intermediate goods. So it's not just harming Brazilian consumers to add tariffs, right? It's harming manufacturers and industries in Brazil that then are planning to make things and export by raising those prices. And a lot of them are in the area of medical supplies and food. So again, you can see why it wouldn't be practicable for Brazil to retaliate within the same sector. So even a large country like Brazil might favor cross-retaliation. They also favor it, if you know about Brazil, you know they have a very strong generic pharmaceutical industry, and so suspending IP rights with regard to pharmaceutical patents is attractive as a threat, and it's a real threat. So the interesting part of both of these stories, though, is that there was no suspension of IP rights in either case. So in the case of Brazil in 2010, the US agreed to a fund. Now remember, this is because we were subsidizing our cotton farmers, and we're incapable in Congress of stopping that subsidization when it was considered a violation. Whether that's reveals some deeper preference or whatever it is, it's just that we could not remove the violation. So what we ended up doing was agreeing to a fund for Brazilian cotton farmers of $147 million a year. So now we're subsidizing our cotton farmers, but also the Brazilian cotton farmers. And then in 2014, we settled with them, and that involved a one-time payment to this fund that we had established of $300 million. And then, in the case of Antigua, we did nothing, and they did nothing. And so this is sort of another part of the story, because we're not just talking about a path to financial damages, we're talking about a path to financial damages in the case that your threat of IP rights suspension is actually something that you could carry through on. Antigua can't carry through, right? There's all sorts of other political reasons why they can't do something like that to the United States, and why it's not a sort of credible threat, because they could have a sort of political fallout in their relationship with us. So these cases show that IPRs are being used as sort of hostages and serve as a pathway to money damages that aren't allowed by the WTO agreements, but only for powerful countries. So the question is whether this is a good thing, whether money damages reached through hostage taking is a good thing. I realize the term hostage sort of sounds like I've taken a position on it, but I'm actually I am thinking through it and puzzling through it, so I'm not sure. What?
Completely neutral.
Right.
They might have Stockholm syndrome.
Okay, so reasons it might be a good thing. The general reasons that money damages might be good, and people have argued that we should be using financial damages at the WTO, is that the money can go directly to the harmed group, right? So this fund goes to the Brazilian farmers who are harmed by the trade violation that we have. Retaliatory measures, as I said, are in other industries. So if I put a tariff on car engines, then maybe I'm helping somebody else's car engine, or hurting somebody else's car engine industry, helping my own, but I'm not helping my wheat farmers in any way. So that's nice, it's targeted. The money doesn't further distort trade, right? It comes from taxpayers generally, so it doesn't add on that second trade distortion like a second tariff would. Specific to having an IP hostage, though, the direct award of money damages would still require compliance by a country that has just showed willingness to violate the WTO. So if you have just an award of money damages, you can imagine that a country that is willing to say, okay, so I violate, never mind that I signed the agreement, I'm not going to bring myself into compliance, maybe they wouldn't pay a money damage. But by having this threat that it seems is actually a real threat, you might be able to get the money damages that otherwise they wouldn't be willing to pay. It puts the power in Brazil's hands, for example, and ensures that we actually do pay them. Reasons it might be bad, so in general, sort of arguments against money damages, it could lead to manipulation. So it might be an avenue for rent seeking. Smaller countries might see this as a great source of potential revenue, and small sorts of violations that normally fly under the radar might then wind up in WTO dispute resolution. And that might just be inefficient. It might be good for us to have small bits of violations without litigation. I know this is not the forum for suggesting we need a little bit less law lawyering, but anyways. Okay, so it's also problematic if we want compliance. So depending on your view of what the purpose is of these retaliatory measures, if what you think is we're better off when everybody's really pushed to comply, then having this lead to money damages doesn't help us with compliance, right? The nice thing, and then another problem is also that and this is specific to the IP hostage again, it's still based on the power of the complaining country. So developing countries have voiced interest in always being allowed to cross-retaliate without having to make any special showings for it, and see this as a pathway to finally getting the big countries to pay attention to them. It doesn't appear that that's the case if you look at what happened with Antigua, and the Ecuador story with EC Bananas is similar, the one I didn't talk about. So nothing happens if you're not big enough, basically. So that's problematic. If we want to do money damages, maybe we should just do money damages. So it doesn't seem to get around that. And then it also might be problematic because the amount of money that's paid might be keyed more towards the value of the IP than it is keyed towards the value of the violation. Now, the fact that the arbitration has already determined a value that can be imposed may sort of act as a break against that happening, but it seems like if the whole point of using the IP hostage is that it forces compliance, the point is that it hurts much more than whatever that amount of money calculated was. So it seems like it might undercompensate if we then are having a pathway to money, overcompensate, because it's key to the value of IP. Okay, and then the sort of what about IP? Is this good for IP or not? Most of my points here are on the negative side. So the incentive structure of IP depends on ex ante certainty and commitments that you will protect the IP. So sure, we'd all be better off if tomorrow all patents were declared invalid and everybody could use them, but what about 20 years from now? And I know that there's debate about what about 20 years from now, but if we assume that there's value in this thing that we have and all write about, then it seems that allowing it to be threatened in this way wouldn't be a good thing. Another problem is that the benefits of IP are meant to accrue to everyone. And so the harms would do so as well. And so the complaints about retaliation getting at the wrong industry are sort of that much bigger if, in fact, IP rights are suspended, because then it gets at everyone. Everyone feels the pain from that. Now, we could just see this as one way of moving the IP lever one way or another, right? We're just making the rights a little bit weaker, but it seems like a really badly calibrated way of doing it. It has nothing to do with when IP rights should be strong and when they shouldn't, and it has much more to do with trade things. And lastly, the sort of multinational nature of so many companies now means that it's really hard to, never mind the good that IP does to all of us in general just by increasing the storehouse of knowledge, it's really hard to concentrate the harms on actual IP, actual US industry, such that the industry will pressure the government. And it's likely to lead to gaming of who holds certain IP rights and things like that with different wings of companies and things like that doesn't actually help anything. So those are my thoughts on the IP thing. They seem to all lean towards the negative. But if anybody has ideas about why it might actually be a good thing, I'd be interested in that. I'd love to hear your questions.
Okay, so you probably explained this and I'm just too dense to get it, but I'm having a hard time seeing why IP here is different than other goods or services in the remedies space. I mean, my former colleague Bob Hudak wrote about the fact that WTO sanctions are almost never executed on because if you're a small country, as you pointed out, you're politically too weak to actually do that. And if you're a big country, you tend to stockpile WTO judgments and sort of keep them for mutually assured destruction, right? So I'm the U.S. and you're the EU, and so you get beef and I get steel, and then you get bananas and I get and if you ever execute, then I'll execute them. Right? So I'm not sure why IP is different than beef or steel or sea turtles or.
So yeah, well, and it's like
I mean,
companies having their patent portfolios, right?
It uses the same way, right? Doesn't it?
So it's used in the same way, but I don't think it is exactly the same. And the reasons I don't think it is the same are these sort of ways that the harms are dispersed. And I also, I don't know what happened with Brazil, right? I mean, I guess I'm not sure why it went quite as far as it did, rather than being settled much earlier in some other way. But it seems like it was used in a way that really could have harmed the U.S.
So I'll probably have to see the paper eventually, because I mean,
Yeah.
I understand what you're saying about the harms being dispersed, but I can think of ways that the banana and sea turtle and other harms are dispersed too. I mean, not exactly the same as you
Right.
joked on.
Right, no,
So, yeah.
it depends on the size
Yeah.
of the market, but yeah, it does change the price worldwide. Okay, again.
I'm sorry, I have a very pedestrian, stupid question. How do we deal with obligations under Paris, Berne, WIPO treaties when these retaliations are imposed? I mean, I realize the problem with the enforcement of those treaties, but at least formally, right, we should be actually in compliance with those outside the WTO system. So how do we solve this?
Yeah, no, I don't think that's pedestrian, or if it is, then I'm equally pedestrian. So they're rolled into the WTO agreement, right? They're by association, but they're good on their own as well through WIPO. I don't know.
I'm asking specifically about the WIPO treaties because Antigua's plan was to use U.S. copyrighted works online, right, to sell them outside of Antigua, which would have been certainly some of the WIPO treaties would speak to that, although Antigua might not be part of that.
Right. Yeah, I don't know. I mean, I know under the WTO they say it's okay to do this, but yeah, the WIPO treaties don't. Look at that. That's an interesting question.
So I just wanted, you're suggesting that there's the opportunity for sort of harassment suits in some ways, right? But the counter story, and I think if you went there a little bit, is that actually my view is there's probably gross under enforcement in a lot of these obligations, right? Because so you painted that as a potential negative, but you may want to flip that into a positive and say, look, these are already suboptimally being enforced, and we may actually, there might be benefit to the system if we have greater enforcement, more case law, more, right? There's that dynamic going on where it could, I'm not saying, I don't know which way it's truly the case, but my view is we probably get suboptimal enforcement now anyway, and so having more cases and more clarity, interpreting the TRIPS provisions could actually be a good thing, so.
Yeah, I think that's possible, and I think there are probably countries that think that's how it should work. There's some that, I think Mexico had a proposal to allow retaliatory measures to be tradable, and so that would be sort of even more of
It's
the
a kind
same
of art
thing.
anyway, but yeah.
Yeah.
Yeah, so there may already be a sort of secondary market, and I mean, the thing with the WTO is so much of it is political, and it's what people are politically willing to do. So most countries bring their laws into compliance when they're found in violation, not because of the remedies necessarily, but because this is a commitment, yeah, because of the politics of it. But yeah, you're right, it could go either way. Okay, did you have?
Yeah, well, I have a question, follow up what Dan said. First of all, I wonder if in the Beef Steel Scholar Conference they talk about the same as IP. No, I mean, the question that I have is that, well, all the threats in IP don't materialize, right? So when you're saying that Brazil cannot arm specifically the American industry, they don't have the power, apparently they do. Well, I mean, if that's the threat that caused us to do something that we were unwilling to do before, then it never materialized, right? They never actually suspend IP. It's just a leverage to get the right industry, to pressure the right government entity to comply with things that they were unwilling to comply, not comply, to compensate things they were unwilling to compensate for before. So it's just a leverage in a game, and it worked. I mean, right?
For Brazil it works.
$100 million?
It doesn't work 300 in the final,
Yeah,
but it was 147 a year.
Yeah, we just spent that.
Yeah.
I mean, just spend it again.
All right, well, thank you.